The adjuster calls 2 weeks after your truck accident with a $40,000 offer. It sounds fair until you learn what your claim can actually include. Federal minimum public liability coverage typically starts at $750,000 and can be $1 million or even $5 million depending on the carrier and what they're hauling. And many companies carry even more than that minimum. They push to settle in the first few weeks before you know if you actually need another surgery or if the injury is even permanent. They're not calling to help you, I promise. They're calling before you understand what your case is actually worth. I'm Jason Marker. I've got 25 years representing truck crash victims across the state of Illinois. What you do not know about recoverable damages right now is costing you money. In this video, I'm going to explain what truck accident cases can be worth, what to look for, and how to recover the most possible. Sarah's 14-year-old daughter was a passenger in a car that was hit by a semi-truck on I-55. The truck driver ran a red light. The girl survived with a fractured pelvis and a 7-inch scar across her shoulder. The insurance company offered $85,000 for medical bills, plus $20,000 for trouble. Sarah almost accepted because she didn't realize that Illinois recognizes permanent disfigurement as its own compensable category of loss. That scar, visible every time her daughter wears a tank top or swimsuit for the rest of her life, had independent value. After the evidence of how that scar has affected her daily life is presented in court, that case can typically settle for more like $265,000. Every case is different, and the facts and the coverage drive the outcomes. But the takeaway is the same. If you don't identify the category of damages, then you don't get paid for it. Most truck accident victims know that they can claim medical bills and lost wages, but Illinois allows recovery for multiple categories of damages that adjusters will never volunteer and tell you. Disfigurement is one of those. There are others that most victims never claim as well. Let's talk about them. Here are the 7 core buckets that you can recover. 1. Medical care, both past treatment and future care that you will need. 2. Lost income wages you have already missed. 3. Loss of earning capacity if your injuries keep you from returning to your prior job or earning what you used to earn before the accident. 4. Property damage and out-of-pocket costs, your vehicle, your equipment, and your related expenses. Those are the bills and the income hits, the ones the adjuster will expect you to claim anyway. 5. Pain and suffering, physical pain and the emotional toll of the trauma. It can be anxiety, depression as well. 6. Loss of a normal life, sometimes described as disability or your diminished ability to enjoy the life the way you did before. Illinois treats loss of normal life as its own compensable element, separate and in addition to any pain and suffering. 7. Disfigurement, visible scarring or permanent changes to appearance. That's where the insurance company quietly avoids paying full value because most victims never know to claim these categories, especially 5 through 7. In rare cases, there's also punitive damages that can come into play. These 7 buckets, most victims claim 2 or 3. Adjusters are counting on you not knowing that the rest of them even exist. If a claim gets treated like it's only about the driver, it can be boxed into the smallest coverage available, sometimes far less than the commercial policy. And the cases can then settle for far less than they should. Truck cases often resolved for significantly more than car accident cases. And it's not just because the injuries are worse, it's because of who you are pursuing. When you pursue the trucking company, you can reach the commercial policy. You can hold the company responsible for what the driver did or did not do while working. You can also pursue directly the company for negligence when the evidence supports it. Negligent hiring if they put a bad driver behind the wheel. Negligent training if they failed to teach safety. Negligent maintenance if they skipped inspections or ignored known defects. And negligent supervision if they pressured drivers to violate hours of service rules. These company-level failures are where cases reach the 7 figures. ELD data can show hours of service violations, and dispatch messages can show pressure to keep drivers driving. That's the evidence that can open up the full policy, and it's the evidence that most victims never know to look for. Punitive damages are rare. What are they? They're not about reimbursing you. They're about punishing truly egregious conduct. This is a higher burden than most civil claims. It requires showing that the defendant knew that their conduct created a serious risk of harm, and they chose to keep doing it anyway. In trucking cases, the facts sometimes support that kind of claim. Falsified logs, knowingly running fatigued, ignoring repeated brake warnings, pressure from dispatch to violate federal safety rules, things like that. The pattern typically looks like this. Messing with logging compliance, ignoring repeated safety warnings and internal recordings showing that the company knew you were at risk but kept moving the truck anyway. Those things are not a mistake, they're a decision. Juries can distinguish between a company that made an error and a company that chose profit over safety. When the evidence shows that choice, settlement leverage changes fast. Illinois follows modified comparative negligence, and under 735 ILCS 5/2-1116, you can recover damages as long as you're 50% at fault or less. If you're 51% at fault, you recover nothing. If you're 50% or less at fault, then your recovery is reduced by your percentage. Here's how it plays out. A jury awards $500,000. The jury finds you 20% at fault because you were slightly speeding when the truck turned left across your lane and hit you. Your recovery becomes $400,000 or 80% of the verdict. The insurance company knows that this is the pressure point, so they try to inflate your fault percentage. They try to do this during negotiations. They claim that you were distracted or following too closely or that you could have braked sooner. Every percentage point that they assign to you is a percentage point that they do not pay. This is why evidence matters. If they argue that you're 40% at fault and they offer you 60% of your damages, you have to evaluate what a jury might do. Sometimes the willingness to go to trial shifts their evaluation entirely. Most cases settle before verdict, but the cases that settle for full value are prepared like they're going to trial from the very beginning. Document what proves the truck driver and the company caused the crash, the ELD and data logs showing hours of service violations, and fatigue risk, maintenance records showing skipped inspections, dispatch messages pressuring speed. Every piece of evidence that proves their misconduct reduces your comparative fault exposure and increases your recovery ultimately. But here's what worries me about these cases that we're dealing with right now. What happens when there's no police report to document what happened? Maybe the accident felt minor at the scene. Maybe the truck driver talked you out of calling the police, or maybe you were just too injured to even make that call. Watch How to Prove Your Car Accident Claim in Illinois Without a Police Report. Watch that next. Those 5 evidence categories are what keep your case alive. And if you need help with a truck accident case now, anywhere in Illinois, please call Marker Law. We'll fight to recover every dollar that you're entitled to. I want to thank you for watching this video, and we'll see you on the next one.